Mr. President and honorary members of the panel, my name is Brandon Zhang, and I appear on behalf of the respondent, the International Federation de Football Association, FIFA. I will speak for 7 minutes and respectfully reserve 1 minute for rebuttal. I will speak on one procedural issue, the appellant's statement of appeal. Turning now to the first submission, we submit that the statement of appeal is inadmissible for 3 reasons. First, the day of the receipt shall begin when the parties had the opportunity to obtain the relevant information. And second, the decision of 31st March is an appealable decision as it contains a ruling which affects the legal position of appellant. And thirdly, the cyber attack does not meet the threshold requirement of Rule 57 of the CAS Code. Turning to the first point, author Antonio Rigozzi, in commentary to Article R49 in the book Arbitration in Switzerland, second edition, at page 498, states, I quote, "It suffices, according to the standing CAS jurisprudence, that the addressee had the opportunity to obtain knowledge of the decision. Whether or not the addressee had actual knowledge is irrelevant. In the present case, if I may direct the panel's attention to paragraph 23 of the record. Here, as at 8 December 2025, the appellant had hired legal counsel in the matter. And at that date, including 31st of March, when the decision was rendered, the relevant parties, i.e. appellant's legal counsel, would have had the opportunity to obtain knowledge, and therefore the statement of appeal filed falls outside the statutory 21-day time limit, as the decision of the date begins on 31st March 2026. Turning now to the second point. According to CAS jurisprudence and case law CAS, in the 2015 CAS decision, GFF versus FIFA and SVGFF, a letter qualifies as an appealable decision only if it affects the legal situation of the addressee, i.e. if it contains a ruling. If I may direct the panel's attention to paragraph 8, which is Exhibit 7. Here, there's a decision from the FIFA Appeals Committee which sanctioned appellant for match manipulation with a fine of CHF 100,000 and also a 5-year ban from all football activities worldwide. This was notified to appellant on 28 January 2026. Therefore, the letter contains a decision, a ruling which affected the legal position of appellant, and therefore, consequently, it is an appealable decision. Thirdly, moving on to the exceptional circumstance that appellant raises. Rule 56 of CAS Code grants permission for reinstatement only in exceptional circumstances. The first limb requires that the party was prevented from acting on time by extraordinary circumstances. And here, we submit that the cyber attack is not an exceptional circumstance for three reasons. First, it has not been proven that there was any causation established. If I may direct the panel's attention to paragraph 30 on page 5 of the record. The mere reference, I quote, the email servers had recently been subject to a cyber attack, I quote, may have been disrupted without necessarily generating delivery error messages. Here, there is no actual confirmation of the specific time period and of where the cyber attack took place. And even if there were affected emails, that does not necessarily mean that there were no error messages generated. And therefore, it has not been proven that the relevant time period can pinpoint when those emails were disrupted. If there is no causation established, that would simply mean it's bare assertions. And moreover, a mere inconvenience cannot be the nature to which the panel grants a reinstatement. In the 2019 CAS decision, PFC Live LLC versus the UEFA, at paragraph 89, the panel held that the appellants prevented by filing the statement of appeal due to the holidays and inconvenience due to the courier could not be held to be a reason for reinstatement and held that statement of appeal to be inadmissible. And presently, we submit that a cyber attack which has not been proven cannot be considered an exceptional circumstance, as appellant had ample opportunity to file the appeal. Accordingly, we pray that the panel finds the statement of appeal inadmissible. If there are no further questions, this concludes my submissions.